not an entirely new bill. The Municipal Systems Amendment Bill was first introduced in Parliament in 2010. And then in 2010, the bill was then tagged as a Section 75 bill by the Joint Tagging Mechanism, which is a committee that is set to decide on the process to be followed by a particular bill. It was tagged as a Section 75 bill, which means that it was tagged as a bill which is not which was not affecting provinces. And it was then passed by Parliament in April 2011 and assented to by the President in 2011. However, there was a court challenge by some who challenged the constitutionality of the 2011 Amendment Act on the ground of tagging, on the fact that it was tagged as a Section 75 bill, when in fact it was a bill which, in the view of some, it was a bill which affected provinces and should therefore have followed a process as indicated in Section 76 of the Constitution. It was further challenged on the second issue of limitation of political rights. The Amendment Act of 2011 was then declared unconstitutional and invalid, and as it failed to comply with the process as indicated in Section 76 of the bill. But the declaration of invalidity was then suspended for 24 months to allow Parliament to remedy the defect. However, the period of suspension expired on the 8th of March 2019, and the Constitutional Court then declared the 2011 Amendment Act as invalid, as the Parliament did not remedy the defect. So this bill is then a revival of that process. It's not an entirely new bill. It's a revival of that process. It has, I think, as Honorable Chairperson had indicated, it had already been passed by the National Assembly. However, it requires concurrence of the National Council of Provinces. And it is therefore on the basis of that the bill has been referred to the Eastern Cape Provincial Legislature, so that the Eastern Cape Provincial Legislature can then consult the public and formulate a mandate which will be forwarded to the NCOP, whether or not the bill is supported or not. I will then, Honorable Chairperson, without wasting any further time, go through the clauses of the bill. Clause 1 of the bill amends Section 1 of Act 32. Clause 1, Honorable Chairperson and members, it deals with definitions. It seeks to substitute certain definitions. The first definition that is being substituted is that of the municipal manager. Honorable members and honorable councillors would know that the municipal managers are appointed in terms of Section 82 of the Structures Act. So what the bill seeks to do now is to then transfer that appointment of municipal managers to the Systems Act, so that it can then be aligned with the appointment of municipal managers. It can be aligned with the appointment of senior managers who directly account to municipal managers. The second definition that is sought to be substituted relates to the definition of political office. And I think as I go through the presentation, it will be clear what the intention of this substitution is. The definition of political office is now defined to mean any position of a chairperson, deputy chairperson, secretary, deputy secretary, treasurer, or an elected or appointed decision-making position of a political party nationally or in any province, region, or any other area in which the party operates, or any position in the party equivalent to a position referred to in paragraph A, irrespective of the title designated to the position. Clause 2 then amends or substitutes Section 54A of Act 32 of 2000. Clause 2 substitutes Section 54A of the Municipal Act. Its purpose is to enable the minister to determine by regulation or guidelines the minimum level of skills, expertise, competencies, and qualification for appointment of municipal managers and acting municipal managers. In respect here of the Act as it stands, just indicate that the municipal manager must have the required skills and expertise, and that is sort of vague and is open to many interpretations. So if the minister then regulates that and provides guideline, it will then ensure that municipalities in appointing municipal managers follow the same process and or appoint people who are at a certain level of skills, expertise, competencies, and qualifications. Further to that, the bill seeks to make an appointment of a municipal manager to be declared null and void if the person appointed to the post of municipal manager does not meet the prescribed competency requirements, which means that person, he or she, does not have the relevant skills, the expertise, and competencies as set out by the minister in regulations or in the guidelines. Further to that, the bill seeks to ensure that the appointment procedures for a vacant post in a municipality is that a vacant post of a municipal manager is advertised nationally to attract as wide as possible a pool of candidates. And the municipal council would then ensure that a municipal manager is then selected or appointed from that pool of candidates who have applied for the post. The bill further provides that if the pool of candidates is insufficient, the municipal council may then re-advertise the post. So if the applications received for a post of a municipal manager are not sufficiently qualified, or the candidates are not sufficiently qualified, the municipal council may then re-advertise the post to ensure that a wider pool of candidates apply for the post of a municipal manager. Further to that, the bill provides that the minister may exempt a municipal council from these strict appointment requirements if the municipal council is unable to attract a suitable candidate for the position of a municipal manager. So if, for instance, a particular municipal council is unable, maybe due to its I'll make an example, maybe because it is a very rural municipality, and therefore people who apply there would not be, people who would have the relevant skills, competencies would not necessarily apply to that municipality. That municipality can then, after following the process of advert and going through the interview, following the process of advert and not getting the suitable candidate, it may then apply to the minister to exempt it from following these strict appointment requirements. Further to that, the bill enjoins municipality to report recruitment and selection outcomes to the MEC for local government and to the minister in order to ensure that municipalities do in fact comply with the appointment requirements and all requirements of the Act. The bill also provides that if the MEC has any reason to believe that an appointment is made in contravention of the Act, the MEC may request the municipal council to correct such an appointment or to apply to court for a declaratory order to force or to enforce compliance with the Act. Further to that, the bill provides that in the event of failure by the MEC or minister to respond to the appointment process and outcome within the timeframes the appointment of a municipal manager would be deemed to be in compliance with the Act, provided that the municipality has submitted to the MEC or to the minister all relevant documents which would enable the minister or the MEC to ensure that all the relevant compliance has been made, and the appointment is therefore made in compliance with the Act. The bill further provides for the secondment of an acting municipal manager by the MEC or minister if the municipal council fails to attract a suitable candidate. Clause 3 of the bill deals with the substitute section 56 of the Act, and it deals with the appointment of senior managers accountable to the municipal manager. The bill enables the minister to determine also in this regard by regulation or guidelines the minimum level of skills and competences and qualification for appointment of managers directly accountable to the municipal manager. This is also to ensure that managers directly accountable to municipal managers have the relevant skill, and that there is uniformity in all municipalities insofar as the appointment of managers directly accountable to municipal managers are concerned. It also provides that the appointment of a director accountable to municipal manager will also be declared null and void if the person appointed does not meet the minimum prescribed skills, expertise, competencies, or qualification. It also proposes that the same procedure applicable to the appointment of municipal managers be applicable to the appointment of directors accountable to municipal managers. It further proposes that a vacant post of a manager must also be advertised nationally to attract as wide as possible a pool of candidates, which an appointment must be made unless the municipal council is exempted from complying with such strict requirements. Further to that, the municipal council must inform the MEC for local government and the minister of the appointment process as well as the outcome by way of a report. If the MEC has reason to believe that an appointment is made in contravention of the Act, the MEC may request the municipal council to correct such an appointment or to invoke a declaratory order to force compliance with the Act. A bill further provides that in the event of failure by the MEC or minister to respond to the appointment process and the outcome within a particular time frame, the appointment of a senior manager will be deemed to be in compliance with the Act, provided here again that all the relevant documents which would enable the minister to come to that decision that the appointment is in compliance with the Act have been provided or submitted to the MEC or minister as prescribed. The bill further provides for the secondment of an acting manager directly accountable to the municipal manager by the MEC or the minister if the municipal council fails to attract a suitable candidate. So the MEC may then decide to second an official within the department if the municipal council has failed to attract a suitable candidate. Clause 4 of the bill, Honourable Chair and members, deals with the amendment of Section 54A and Section 56, and is just a technical amendment which substitute the word municipal council municipality with the word municipal council in wherever it appears in Section 54A and Section 56 of the Act. Clause 5, Honourable Chair and members, deals with the amendment of Section 57 of